Okay, we're ready to get started.
Today is Monday, October 11th, 2021 at 5:30 p.m. We are in the Brecksville-Broadview Heights Education Center, 6638 Mill Road, Brecksville, Ohio. This is a special meeting of the Brecksville-Broadview Heights Board of Education in public for the purpose of participating in a training program regarding open meetings, sunshine law issues. This meeting will be live streamed via YouTube and will be recorded for later viewing. Consider subscribing to our YouTube channel where all recordings are posted. Shall we pledge allegiance?
Pledge allegiance
to the flag of the United States of America, to the republic for which it stands,
under God, indivisible, liberty, and
liberty and justice for all.
Okay, roll call.
Mr. Dosen, Mrs. Kramer,
Yes.
Mrs. Mack, Mrs. Wigman,
Yes.
Mr. Peterson.
Yes. Item 2, special meeting, A, training program, open meetings, sunshine laws. Roll call.
You would need a motion.
I need a motion.
So moved.
Second? Second.
Second, sorry.
Mrs. Kramer,
Yes.
Mrs. Wigman,
Yes.
Mr. Peterson.
Yes. Okay, Jennifer,
Yes,
you're on.
hi. Thank you. I have a PowerPoint and there we go. Okay. Here we go. There. All right, can everyone see that?
Yes.
Great, wonderful. I am Jennifer Harden. I'm the Deputy Director for Legal Services here at OSBA. And I want to thank all of you for inviting OSBA and me to come today and talk to you virtually about the open meetings law and public records laws. And I hope this will be more of a dialogue than a monologue. So please feel free to ask me questions if you have them. You are very tiny on my screen, so you might need to interrupt me. If I see a hand up, I will certainly respond, but if I don't, feel free to jump in and tell me that you have a question. Looking forward to talking to you tonight.
Thank you for your time.
Oh, you're welcome. We're happy to do it. This is one of the things we really enjoy doing, so thank you for having us. So first, I'm going to be talking a bit about the open meetings law, which is found in Revised Code Section 121.22. And I've just put down 121.22 here, even though there are other provisions in Title 33 that deal with the open meetings laws as they apply to school districts. And there actually are other provisions in Chapter 1 that deal with open meetings. So we'll be talking about a bunch of different ones, different sections there, but this is the main one. And we'll also be talking a little bit about public records. And the main statute for that in Ohio is 149.43. Sunshine law, of course, is what we call this because of that famous, I want to say it was a Supreme Court case, but maybe not, where somebody said that sunshine is the best disinfectant. And government should occur in public with the sun shining on it. So we'll start out talking about open meetings. So we're going to be talking about how boards are required by law to conduct their meetings. Can you hang on for just 1 second? I'm sorry. I just realized I can't see my clock while I'm sharing my screen, and I don't want to go way past my time, so I needed to pull my phone out. Okay, so we're going to be talking about what the laws are that govern how boards, all public boards, not just school boards, are required to conduct their meetings. So there are 4 main requirements of the Open Meetings Act in Ohio. And they are, first of all, that public bodies have to conduct business and take official actions in meetings that are open to the public. And of course, during the pandemic, we all know that took a different appearance. Instead of meeting in a room together, we were meeting virtually. So that was different. It was temporary. As you know, that ended as of July 1st. I want to say July 1st. Is that right? 2021. There has been some talk about possibly the General Assembly reopening that option at some point in the future, but I don't know how active that is. At one point, there was a provision to allow virtual meetings to continue under certain circumstances through the rest of this year, but that didn't happen. It was taken out of the budget bill. So at this point, we have to meet in person and conduct business in meetings that are open to the public. Public bodies have to establish a method of giving notice of meetings to the public, and we'll talk about that in a little bit more in just a second. Minutes have to be taken and must be open to the public for inspection. And finally, a public body can only go into executive session for limited reasons that are listed in the law. So those are the 4 main points of the open meetings law at Ohio. You have a policy that reflects the law. It is 169.2, I believe, which talks about notice and other things. We'll talk a little bit more about your policies as I get to them. I've looked up your policies and we'll be referring to them as I go through my presentation, the relevant sections. One thing to consider is that a board committee is considered a separate public body and is also subject to the open meetings law. And again, you have a policy that reflects this, your policy 0155. So if you have a building and grounds committee of the board, or if you have a policy committee of the board, or a finance committee of the board, you would have to, when you have meetings of those committees, you would have to make those an open meeting and follow the same notice requirements, take minutes, make them open to public inspection, and follow the executive session provisions, just as you would for a board meeting. That's true even if the committee has fewer than a majority of board members on it. And it also doesn't matter if no board members serve on the committee. If you, as the board, establish a committee, that committee would be subject to the open meetings law, even if none of you were members of the committee. The exception to this is the superintendent committee. Your superintendent may create committees, and if she does, those are usually not public bodies, so subject to the Open Meetings Act, but it needs to be truly a superintendent created committee. It can't be a committee that the board has asked the superintendent to create. Does anyone have questions? Yes.
I do. Jennifer, this is Britt Wigman. Thank you again for your time. Specifically related to board committees versus superintendent committees.
Yes.
What is a process by which, or can, I guess, a board committee be moved to a superintendent committee or vice versa? And what's the value of either?
It's a good question. If it is a committee that the board has created and the board feels is necessary, the likelihood is that that's going to be considered a board committee, even if the board were to say to the superintendent, we'd like you to create this committee instead of us. Because it's achieving, I think a good way to examine it is look at the objective the committee is intended to achieve. If it's an objective set by the board, for that committee, the likelihood is that it is a board committee. Now, let's distinguish that from an objective you set for the superintendent, and as part of her performance of her role, the superintendent decides that it would help her to have a committee. You have not set an objective for the committee. You've set an objective for the superintendent who has chosen to create a committee. That would be considered a superintendent committee. The value, I mean, they're both valuable. I know people are sometimes leery about the open meetings law. That should not be a reason to change the nature of a committee. And I know that's not what you were suggesting, but that's the best distinction.
Okay. No, and I appreciate the distinction, especially as it relates to superintendent goals. I think that's a valuable sort of caveat to take away here.
Well, and we have board member committees and district committees, and I'm not sure by that description which were established by the superintendent originally and which were established by the district, by the board.
Yeah, and
Okay.
I wouldn't know that either, but it's a good question, because if those district quote unquote committees are actually committees that were created by the board, then they should be following the open meetings law. It's very possible that that's the distinction that your district has chosen to make between board committees, those are called board committees, and district committees, which are actually the superintendent's committees. That's something you should be examining. Now, the fact that a board member serves on a superintendent committee doesn't make it a board committee. So if the superintendent, for example, decides to set up a committee to review some practice the board is engaged in or the district is engaged in, that's part of her overall governance of the day-to-day operations of the district. And she asks one of the board members to serve on that superintendent's committee, it's still a superintendent's committee.
Okay. And then by virtue of evaluation, as I suspect we may undertake at some point in the future, given some additional details here, if there's a determination that a board committee is no longer required, or so, for instance, if, of the 5 board members of this district, no one was around for the creation of a handful or one of the committees that are currently established, is there a particular process for absolving that committee? Or
No,
is that
the board just, the committee can become, there certainly are times when committees, what's the word I want, don't meet actively, they become dormant. If you want to memorialize that and say, this committee's been dormant for a certain number of years and we don't believe we need it anymore, you can certainly do that. You can always re-examine later on whether you want to recreate a committee. I'd say take a look at that policy 0155. Unfortunately, that's not one of the ones I printed. But if you want to look at that policy and see what it says about how the board creates committees or whether it talks about sunsetting committees, public agencies do that all the time. They look at whether a particular committee or board or commission is working or is still needed, and they sunset them. So that's certainly an appropriate thing to do if you feel that you have a dormant committee that isn't needed anymore.
Yeah, I believe we may have addressed this late last year and talked about maybe revisiting it during the organizational committee, the organizational meeting at the beginning of this year. And I think it never came to fruition. So that might be something we look at going forward.
Yeah.
I'm writing a note to myself because we do have a board committee information sheet, and I can send that to, what is your preference? Do you want me to send it to the treasurer, the superintendent, the board president?
Yeah.
All of you?
We'll make sure it gets distributed to the rest of the board.
Okay,
Yeah.
and
Given your
But that's a-
communication with Fred, I think sending it to Fred.
Yeah.
Would be
okay,
That's a good idea. And another thing that I think we need to look at is what we're doing to announce our board committees meetings.
I'm going to hazard to guess the district committees are the ones
yeah,
that set up, and the others are the ones the superintendent set up. Just so.
I'm sorry, I didn't hear that, but what I wanted to say was that that committees, you need to follow the same process for a committee that you would follow for
The board.
for the board meeting, exactly. So the notice requirements are just the same. If it's a regular meeting, it would need the time and place, a TP notice, I call it, just because it's easy for me to remember. If it's a special meeting, it needs a TPP, time, place, and purpose notice. And then of course you'd have to take minutes. I'm sorry, I'll go back to the previous slide. You'd have to take minutes. And you would have to go in, they would have to go into executive session only for the reasons that are listed in the law. It's far less likely that a committee of the board would have a reason to go into executive session, but if they do, they have to do so in compliance with the law.
I'm not aware of that ever happening, but
Yeah, I can't imagine that it would. The kinds of things that, I suppose that there could be a board personnel committee, maybe that's possible, that might be doing some preliminary activities, but it seems unlikely. So the next thing I wanted to talk about is just what is a meeting? And meeting is thankfully defined for us in the law. It is defined as a prearranged discussion by a majority of the members of a public body of the public's business. So anytime the board is doing these four things, pre-arranging a discussion for a majority of the members about public business, that is considered a meeting, and it would be subject to the open meetings law. Sometimes people get confused about this because we hear this all the time. People will say, well, we're going to have a board retreat over the Christmas, the winter holidays. We're going to come together at the library and discuss things, and we're just really going to work through stuff. And the way we can do that best is if we don't make it a public meeting. That unfortunately is not permitted because that's a prearranged discussion, assuming a majority of the members are there or plan to be there or are there, and it is about the public business. So even though it's called a retreat or a working session or a think tank, whatever it's called, if it meets this description, it is a public meeting, and it must be noticed, must be open to the public, and all other requirements must be complied with.
How does, oh, Jennifer, that
Yes.
prearranged adjective is really limiting. How does that get construed in the case law?
Basically, that's a really good question. And it kind of comes up in what we're going to talk about next, which is email communication. The courts have been very broad about what they've considered a prearrangement. Certainly for a meeting like the one you're having now, where people gather together in a room, prearrangement is really easy to see. There's some kind of email or mail or telephone communication among the members saying this is when we're going to be meeting, and this is what we're going to be talking about, and this is where we're going to be meeting, et cetera. However, the courts have also said that if there is a prearranged consensus of the board to discuss over email or electronic communications any board-related topic, that can also be a public meeting or a meeting under this description. And that's interesting because you don't send people emails or texts saying, all right, we're going to have an email discussion about something starting at 6 p.m. Go. That's just not how that works. But the court said, yes, it was prearranged. This group, which was a school board, decided to discuss X topic via email. And that made it a meeting under this description. And for that reason, it was improper. They couldn't have done it properly because they couldn't have done it publicly.
Their note says any gathering that meets these four requirements is a meeting, no matter what the board calls it. How about
Right.
any gathering that meets any of those four?
No, let's say you all decide to get together for a celebratory luncheon to, congratulate a staff member for something. Well, maybe that's not a good example. To congratulate a staff member for having, their 100th grandchild. That could be prearranged. It could involve a majority of the members of the public body. It would certainly involve discussion, but it wouldn't be about the public's business. So that would not be a public meeting.
Okay. Thank you.
Sure. I mean, another example, a far more common example is all five of the board members decide that they're going to go to graduation. And while they're at graduation, they may discuss, how happy they are to see this group of students graduating. As long as they don't get into how those students graduated or why those students graduated, it's fine. All right.
Thank you.
Let's talk. Sure, absolutely. Let's talk about regular meetings. So regular meetings are the ones that you set at your organizational meeting in January. That list of meetings you come up with, those are your regular meetings. You have to meet at least once every 2 months. My guess is that you meet far more frequently than that. Most boards do. And you can consider any and all topic that's properly before the board. You have to set a policy establishing your notice requirements. And the notice is a TP notice, time and place. In your case, the policy is 0164. And you have provided in your policy that notice, a schedule of the time and place of each regular meeting is posted annually on the district's website, published in its official newspaper, and posted at the district office. So that is your means of notice. for your your regular meetings. You also have a policy that talks about a rescheduled regular meeting. And in that case, you call it, you consider that a regular meeting. And again, that's in your policy 0164. All right. Special meetings are a little bit different. They're TPP notice. You're required to, anytime you meet, and you're not meeting at a regularly scheduled time that you established back in January, that is considered a special meeting. Topics that you can discuss in that meeting are limited to those that are noticed to the public in advance. So if you have a special meeting to discuss a specific topic, a specific contract, whatever it would happen to be, that notice has to include time, place, and purpose. And it has to, your meeting itself has to be limited just to that topic or topics. Special meetings can be called by the board's president, by any two board members, or by the treasurer. Any of them can call a special meeting. Again, you have a policy on this. It's 0162. It is completely consistent with the requirements in the law. All right. So as I said, TPP notice for special meetings, time, place, and purpose or purposes. The purpose that you describe in the notice has to be specific enough that the public will know what's being discussed. It can't just be general purposes unless your special meeting is a rescheduled regular meeting. Some boards do their rescheduled regular meetings as special meetings. You also can't do catch-all language. Sometimes boards like to say, and any such matters that come before the board, or and any business that it must be discussed in a timely fashion, or whatever. You can't use that language as a catch-all to allow discussion of other topics, because the public would not have sufficient notice of what you're talking about to meet the requirement in the law. The notice has to be given to board members in writing 2 days before the meeting, and to the news media and public 24 hours in advance. And I believe in your case, your notice, the method of notice is to place it on the website. Yes, posting the notice on the district's website, and that is in your 0164 policy. And your policy on special meetings is 0165.2. There is an exception to the timing of the notice. Everything else is the same, but the timing is different for emergency meetings. And emergency meetings are a subset of special meetings, but they are for purposes that are truly emergencies. So an emergency is something that requires immediate official action of the board. The courts have said we're going to rely on the board's reasonable discretion to determine what is an emergency. Some things to consider are, is this really an emergency? Is this something that's been sitting around for a while and we just haven't acted on? For example, if the boiler of the building's heater in one of the buildings breaks in July, the likelihood is that the court would not consider that emergency. If it breaks on February 1st, the likelihood is the court would consider that an emergency, because obviously you need your heating system to be working in order to have school in February, usually. And again, the notice has to be time, place, or purpose, and it has to be issued immediately to the media that have requested such notice. And immediately means as soon as you know for sure you're having the emergency meeting. Any questions about that? Okay, cool. Let's move into, sorry.
So there's not necessarily a time restraint on an emergency meeting. You could call an emergency meeting, fairly short notice.
Yeah, there certainly are times when a board has to meet very, very quickly indeed. Something has happened that requires the board's immediate action, and that's never something good. So we hope that won't happen, but it does happen occasionally. A board, maybe the district has a fire at its administrative office, and the board has to meet quickly to determine where its administrators are going to be working for the next however long it takes to repair the building where they used to work. Or as I just said, the boiler breaks in a building on February 1st and classes are supposed to resume on February 2nd. Those are situations where the board may have to act very fleetly, and the law allows that. But you do need to provide some form of notice as soon as you know you're going to be meeting.
Thank you.
Sure. So now let's talk about executive session. Executive session is where the board meets privately, away from the public and away from, in some cases, other people. The only people who are legally entitled to attend, an executive session of the board are the board members themselves. The board may choose to exclude its superintendent and treasurer. Most boards don't, for very good reasons, but there may be good reasons to exclude them in a certain situation or one of them, and the board can do that. The board can also invite anyone it chooses to attend an executive session. If for some reason there's a family member, a board, student family member, or another district employee, or the attorney for the board that you need to have an executive session, you can certainly invite them to come into executive session with you. And the most important question is, how do you know if a topic is appropriate for executive session? Well, the law lists them in 121.22G. There are 8 matters, although one of them only applies to hospitals. You're not a hospital, right? So the reasons that you can meet are certain personnel and student matters, purchase or sale of some properties, imminent or pending lawsuits, but in order to use the executive session for that, your lawyer must be present. It requires that the lawyer is present and that you're having discussions with the lawyer. Preparing, conducting, or reviewing collective bargaining negotiations, matters that are required to be kept confidential by federal or state law, and details of security arrangements are the main reasons. One thing to keep in mind, and this is something that people sometimes forget, you can't just go into executive session and say, we're going into executive session for one of the reasons discussed in 121.22G. Or we're going into executive session for one of the reasons discussed, for a personnel reason discussed in 121.22G1. You have to be specific about the reason you're going in. So assuming it is for a personnel matter, you would have to say the motion for the board to go into executive session to discuss the discipline of a public employee. That is specific enough that you can use that reason to go into executive session. You don't have to name the employee or describe the situation or reveal anything that would disclose who the person is, but you do have to be specific about what it is the board will be discussing. And then when you're in executive session, you have to be disciplined about remaining on that topic. If your discussion verges into some other area or onto some other topic, that's when the president needs to say, okay, we need to stop this discussion. We're outside of the scope of our motion. If this is something that is appropriate for executive session, we'll go back into open session and make another motion and come back in. If it's not, we need to discuss it in open session. The procedure to enter into an executive session is there must be a motion with the specific reason, as I just said, that the board is going into executive session, and a roll call vote. Now, one question that sometimes comes out is, do we need a roll call vote to get out of executive session? No, you don't. And in fact, you shouldn't be voting in executive session. So, I mean, if that's the way you're doing it, that's fine, but you don't need to, and it's not an official vote of the board. You just need to have a consensus that the executive session is over and you're going back into open session. Any questions about that? Cool. So here are some of the reasons that people have gone into executive session that they shouldn't have. Discussing reductions in force or personnel policy discussions, budget, continuous improvement plans, tax abatements, TIFs, and other revenue sharing agreements, tax levies and levy campaigns, bond levies and bond levy campaigns, hiring an architect or lawyer that is not an employee. They are a service contractor, so that would have to be done publicly. Booster activities and discussing your process for interviewing candidates. The interviews can be done in executive session, but the process cannot, the process discussion. Did I hear a question? Okay, cool. So let's take a minute to talk about minutes. Minutes have to be promptly prepared, and your treasurer is charged with that duty by law. You can use a means of recording them either by audio or video. Most people use notes. The minutes don't have to be a verbatim record of the board's discussion. They do have to include sufficient information for the public to understand and appreciate the rationale behind the public body's decisions. So somebody reading that, the minutes would have to be able to see, okay, this is generally what the board discussed, and this is why it reached this decision. The minutes have to be approved by the board, and in your case, your policy provides that they will be part of the consent agenda. Although if for some reason someone wanted them taken off the consent agenda, that could occur. And then they have to be maintained and made available upon request. And you have a policy on minutes, which is 0169.1. 0169.1. Oh, I'm sorry. No, that's not minutes. That's public participation. Minutes is 0168. I apologize. Does anyone have questions about that? Okay. Speaking of public participation, let's talk about that. As you know, probably know, you're not, as a Board of Education, required to provide for public participation, but most boards do, and for good reason. If you allow public participation, you can regulate the time, place, and manner of public participation, but you can't regulate the content. And that's because this is highly protected First Amendment speech, and citizens have a right to talk about within reason, to talk about topics of their choice. You also can't regulate the identity of speakers, and the minutes that are taken by your treasurer have to reflect the identity of the speaker and the nature of his or her remarks. They don't have to go again into a verbatim recitation of the comments, but they do have to describe the remarks generally. So examples of permissible time, place, and manner restrictions include when members of the public will be allowed to address the board. So at what point in your meeting do you have public participation? That is a permissible regulation. You can regulate the time period for comments, and your board does what most boards in the state do, which is 3 minutes in total, 30 minutes per speaker. It's permissible to require public speakers to sign up before speaking. And it's permissible to require that comments be confined to agenda items that are before the board.
Can you tell
What
me,
you, yes,
what do you mean by the board cannot regulate the identity of the speakers?
you
what does
can't
that mean?
limit speakers to certain groups.
Oh, okay.
That would be an impermissible regulation.
Understand.
Okay. What you cannot regulate is negative viewpoints or about the district, because that is a viewpoint regulation, which again is protected by the First Amendment. You can't prohibit people from mentioning the names of employees. That's a content regulation. You can't restrict certain speakers because they have a track record of being negative about the district or having criticism about the district, because that's an identity policy. And I've noted that OSBA, has a policy on point, but your policy is a Neola policy, which is 169.1. And it's a very comprehensive policy. Excuse me. Yeah. Sorry, I just was looking at another part of my notes. Here are some things that people talk about in comments that you may want to handle in a particular way. When people come up and have comments about staffs or complaints about staff, remember to follow your chain of command. In your case, your policy 9130 talks about public complaints, and it discusses how the board will handle public complaints. And it's good for the citizen who's making a complaint to know that they should be following the proper process. They can then ask, as part of your process, for the board to discuss or hear their concerns. You can also ask the person to speak to you in executive session on those concerns. That's permissible under 121.22G1 because it's discussing a complaint about a public employee. Complaints about students are a little trickier because you have an obligation to maintain confidentiality of student information. Complaints about students should be heard in executive session. Although the parent of the student who is being discussed can waive that. Your policy 55-1701, it, for example, talks about complaints about bullying. If a parent were to come to a meeting wanting to talk about a specific student and bullying, that's something you would probably be best to encourage them to do in executive session or by following the proper process that's in the policy. Here's some general strategies for public comment sections. You don't have to answer questions. Public participation is a time for the public to speak. It's not a time for them to be asking you questions that you have to immediately answer. It may not be possible for you to immediately answer. You can, if you choose, speak to matters that are brought up in public comments. If you're doing that, in your case, remember that your board has selected the board president as the board's official spokesperson in policy number 0148. So you should be following that protocol if you're going to respond to a member of the public. You don't have to engage in Q&A on a subject if you're not briefed on it or prepared to address it. It may be, in fact, detrimental to the district for you to engage in that kind of discussion in an open meeting. When the public's speaking, even if they're antagonistic, it's important that the board members remain calm. Remember to thank people for their comments. It means a lot when citizens are interested in government and come out and say what they feel. It's the best way. It's one of the best ways for you to know what your constituents think and feel about what you're doing. So you need to thank them, but then you need to move on. And certainly, if there are things that are brought up by one or more speaker at a meeting that you know you need to follow up on, you can refer those to the superintendent to follow up on them, because that's really not your role as board members. You have very qualified administrative staff, professional staff who can handle these matters. So when they come up, refer them for further investigation or follow-up to the appropriate staff person. Any questions about that? All right. So let's talk a little bit about violations. First, yes, I'm sorry.
About the screen that you just had up, if you could.
The one before this?
Yeah.
Yes.
What if you have a board member who does like to answer questions? Anyway, what is your suggestion as the best way to handle that?
Well, again, remember that the board in its policies has selected the board president to be its spokesperson. So if there is a unified board position on a particular matter that a citizen is bringing up during public participation, the board president should be the one responding.
And what if another board member responds?
I mean, without knowing the specific situation, and I'm not asking you to tell me, I would say it may be something that the board needs to discuss amongst themselves to make sure that everyone understands, here are the guidelines we have established for ourselves. It doesn't necessarily help the board to have individual board members giving their opinions or their positions if they are not a unified position of the board.
Okay. Thank you.
So, oh, sure. So, and if the Open Meetings Act is violated, that invalidates actions of the board if they result from discussions or votes from the meeting that was not open to the public, or if they were taken in a meeting that was not properly noticed. So it's important for you to know that following these guidelines isn't just a recommendation, it actually invalidates your action. And if someone were to bring a complaint for a violation of an Open Meetings Act, of the Open Meetings Act, it can result in an injunction by a court for the board to comply, including a $500 fine, court costs, and reasonable attorney's fees. If the board issues such an injunction and a board member violates that injunction, the board member can be removed from office for that violation.
Is the $500 fine one fine against the whole board, or $500 per board member?
That is a really good question that I cannot answer. I don't know the answer right now. Hang on a second. Let me just check and see if I wrote that down in my notes. I do not have that down. I will check it and get back to you.
Thanks.
I think it's against the district rather than against individual board members. But I'll check. And when I say district, I mean the board, not the district. Although the district would be paying it. A couple of resources that we have available are a fact sheet on the Sunshine Law, which is available on our website, and a journal article on public participation. I can email this PowerPoint to Mr. Peterson, and he can share it with the other board members, the superintendent and treasurer, so that you'll have these links.
Thank you.
Sure. So let's move into the Public Records Act, which is the state requirements governing board records. And I shouldn't just say state, because there are federal requirements as well. And again, this ensures government operates in a transparent manner by making records available to the public. First of all, 149011G defines a record. A record is any document, device, or item, regardless of its physical form or characteristics, including electronic records, that was created, received, or comes under the jurisdiction of a public office, and which serves to document the organization, functions, policies, decisions, procedures, operations, or other activities of the office. So that is a record. That is an exceptionally broad definition of record. A public record is something that meets the definition of record and is kept by a public office. So there are records, and then there are public records. A second. Okay. So according to the Public Records Act, records have to be promptly prepared and made available for inspection. So there are two ways citizens can access public records. They can ask to come in and inspect public records, and they can ask for copies of public records. If they are asking to inspect public records, they have to be prepared promptly. If they're asking for copies, they have to be provided within a reasonable time. The district can require the requester to pay cost of production if the requester asks for hard copies. It says disks here, but that of course at this point means flash drives, thumb drives. And you have your requirement, or your policy allows you to charge 10 cents a page and $6 for a flash drive. And each district has to have a records policy, which is posted in the district, posted in district buildings. So you probably have, I know you have a public records policy because I've seen it. It is policy 8310. And the likelihood is that that policy is in each of your district's buildings. It should be, and I'm guessing that it is. One specific requirement of the Public Records Act is that each of you board members is required to have training on the Public Records Act, and the training has to be approved by the Attorney General. So the training that I'm doing for you right now is not this required training. It's a 3-hour training class that is approved by the Attorney General's office. The only people currently teaching that training are the Attorney General's office and the Auditor's office. There's no, as far as I know, there's no one else in the state who is approved currently to provide that training. You can attend the training yourself once every 4 years, once each term, or you can send a designee. Many boards send their designee to take the training probably every 2 years, because you have new terms beginning every 2 years. Sorry, what was your question?
Oh, nothing.
Kellen,
Okay.
Ellen questioned if I went last year, and I did, as a new board member last year.
Yep.
Yeah.
A lot of, I mean, I think it's not a bad idea for the board members to go themselves, but it isn't required if you have a designee who's doing it. And excuse me, the truth is that you're not really producing public records yourselves. That's being done by someone within your district, but it's still a good idea to know what the law is. If you have a new board member appointed after a vacancy, remember that that new board member would also have to attend the training within a relatively short period of time. So I always say your mission is to find out who your designee is and when they last attended training. If any of you serves as the Career Center representative for your board, you're not required to attend training for that position, just for your elected city board seat. So student records are confidential both under federal law and state law. And you have a policy 8830, which is your policy on, is that your student records policy? Yes, that's your student records policy. FERPA, that is not the right that is not the right acronym. I apologize. It's the Family Education Rights and Privacy Act. I should have got that. Regulates student education records. And those are records that are maintained by the district and contain personally identifiable information about individual students. Direct identifiers are things like name, social security number, photo. Indirect indicators, identifiers are things like the parents' names, the family's address, personal characteristics. The bottom line when you're looking at student records and trying to determine whether you can disclose them is, do the records allow someone to identify a specific student? If the answer is yes, don't release the record unless there's an exception in the law and you meet the exception, or you have concern to release from the parent or the student if the student is over 18. There is a lot of case law and a lot of information about student records out there. The federal government has a website specifically devoted to FERPA and to protection of FERPA records. I think I have that linked later in the PowerPoint, but if not, I will put it, no, it looks like I don't. I'll put it into the email that I'm sending to Mr. Peterson. A recent case law in Ohio, one recent case in Ohio, interesting, because I'm a lawyer and I think these things are interesting, is that records of deceased students are not subject to release as public records, even though there's no one to consent to the release because the student was an adult at the time the student died. The Student Privacy Act in Ohio, which is 3319-321, bars release of those records. That's a state XRL CNN versus Bellbrook Sugar Creek, if you're interested. And here are some FERPA exceptions. These are some situations where the district can release student education record even if they don't have consent. First of all, it's directory information, which is listed in your policy. I'm sorry, I'm just checking to see if I have that policy printed out. It looks like I don't. Is being released to a school district official with a legitimate educational interest, is being released to another school to which the student is transferring, is released subject to a court order or a subpoena, or is released to health and safety officials in an emergency. This is absolutely not an exhaustive list. There are far more exceptions in FERPA, but these are the ones that are going to come up most frequently. So our resources available on public records are our 5 fast facts on public records. And we have a journal article, relatively recent journal article, which talks about what the law requires and what it allows with respect to FERPA records and release of those records. Other available resources include the Attorney General's office. They have a Sunshine Law manual that they issue every year. It's actually a joint publication of the Attorney General and the auditor. It for years had a yellow cardboard cover, so it is known kind of fondly as the Yellow Book. If you search for Ohio Attorney General Yellow Book, you'll find it. It's a great resource if you have questions about the Sunshine Law, either open meetings or public records. The local government records program at the Ohio History Connection is also a great source of information about public records law and open meetings law. About the public records law, not open meetings. Every school district should, and I'm sure you do, have what's called a retention schedule, which sets forth the amount of time the district will retain certain kinds of records and how it will retain them, who's responsible for them, and when they will be destroyed. It's the local government records program at the Ohio History Connection is an excellent resource for checking to make sure that your time periods are reasonable and comport with recommendations made by the state. with respect to retention. Does anyone have any questions for me? This is not my dog, but he's really cute, so I had to put him in my PowerPoint. No?
Nope.
All right. Well, I'm almost out of time. I left a little bit of time at the end for questions. So I'll promote OSBA instead. First of all, I'm going to tell you, if you haven't done so already, you might want to subscribe to the Legal Ledger blog, which is the blog produced by the legal division here at OSBA. This is the URL for the blog. We blog at least once a week on recent legal developments and issues that are raised to our legal staff. So for example, last week's blog was about what the board does if not enough people are running for seats that will be open in January. And I know in Ohio this year that doesn't seem like it's a problem, but there are some districts where it's a problem. So the blog talks about how the board handles the appointment in January to that empty seat. We'd also love you to follow us on social media. We have a Facebook page. We have Twitter. You can visit our website at ohioschoolboards.org. It's chock full of information on a variety of different topics. If you haven't checked it out already, please do so. And finally, here's my contact information. I hope you'll get in touch with me or someone else here at the division if you have questions. We are happy to answer them. We have a legal hotline. We don't call it a legal hotline, but that's basically what it is. You're welcome to call and ask questions of the legal division anytime you have them. Does anyone have questions now?
I think you've done a good job throughout your presentation of answering the questions that we had on each topic.
Great. Well, if that's the case, then I think I'll just say thank you very much again for the invitation. Don't forget to go back and look at the policies that I highlighted, your individual board's policies that I highlighted, so you know what your own board has decided to do in the past. I'm going to be sending you 3 things. I'm going to be sending you the PowerPoint. I'm going to be sending you that resource on board committees. And I'm going to be sending you the link to the electronic records. It's not the electronic records. Maybe it is. The federal FERPA website. Was there anything else you needed?
I think that was it.
I think that's,
Thank you so much, Jeff.
yeah, Jennifer, thank you very much. It's been very
You're
useful.
very
and
welcome.
Very informative too.
Oh, good. Well, you're very welcome. And please call us if you have any follow-up questions. And I will stop sharing my screen now and say farewell.
You have a good evening.
Thanks, Jennifer.
Thank you. You too. Bye.
Bye-bye.
Let me see if I can go find Craig to get us out of this. 'Cause he has to stop recording and
Oh, well, don't we need to adjourn the meeting?
we do, but I want to make sure he can record everything.
Oh,
It should be on record. Okay, item 3, announcement of meetings. A, regular board meeting, October 27th, 2021. Item 4, closing items. Adjournment, roll call. I need a motion, I'm sorry.
so moved.
Second.
Roll call,
Mrs. Kramer,
Yes.
Mrs. Wigman,
Yes.
Mr. Peterson.
yes. Meeting is